So Gary Kalassi, I'm the CEO at Alexa Translations. This is our sixth webinar on the topic. Bill 96 has been certainly a piece of legislation that has been top of mind for many of you doing business in Quebec and that are based out of Quebec. And with the regulations that came out at the end of June, it provided an opportunity for us to say, let's do actually a further one to address any clarifications, but also to think through what are some of the practical steps and considerations that should be there for in-house counsel, marketing communications teams, HR departments. It affects multiple departments within each organization. But I'm going to start with an introduction of our partner for this session, Counsel, and introduce the founder, Avi. And Avi, if I could ask you to introduce yourself, but also a little bit about what Counsel does, because knowing that not everyone here today is a Counsel member and may not be familiar with Counsel.
Thank you so much, Gary, and thanks everyone for joining us today. So like Gary said, my name is Avi Weiss. I run a company called Counsel. We are a professional network for in-house lawyers all across Canada. We're starting to expand to the US, and we offer our members, but also other folks, access to resources. So we do a lot of webinars just like this one, and we do events, fun dinners, socials, anything to help you grow in your professional endeavors, network with your peers, and get access to strategies and tips from others who can help you in your day-to-day. So excited to be here, and thank you so much, Gary.
Well, thank you for the partnership on this, Avi, and I think this will certainly be valuable to a lot of the in-house community. And
Sure.
I will start with an introduction of our panelists next, and excited to have Tanya and André returning. They've certainly been on our previous webinars. And Francois, welcome. With introductions, if I could ask Tanya to go first, and then Francois and André, because it'll also be a bit of the order in which I'll be asking you to speak next. So Tanya.
Hi, everyone. My name is Tanya De Silva. I'm a partner in DLA Piper's Montreal office. I practice primarily in employment law as well as commercial litigation with a focus on class action defense. I'm very happy to be with you today.
Thank you, Tanya. Francois.
So hi, everyone. I'm Francois Larose. I'm a Quebec lawyer and trademark agent. I've been practicing IP law for over 20 years now. A big chunk of my career was with Bereskin & Parr, and we recently merged with Smart & Bigger. So now I'm a principal at Smart & Bigger, practicing mostly in trademarks, also a bit of copyright. And as you can imagine, language laws in Quebec is a big chunk of my practice, especially in the past few years. If anyone asks who's benefiting from Bill 96, I'd say it's the lawyers. And any event, I've been speaking many events, webinars, conferences on this topic, and I'm really happy to be here today.
And André, if I could ask you to also introduce yourself, and then a little bit about your background as well. You are our in-house counsel, resident in-house counsel for the purpose of the call. And I think your background will certainly be interesting, and also some of the questions I'll be asking you will be in line with this.
Hi, everyone. André de Moyeve, currently head of legal at Crédit Agricole Corporate Investment Bank. And previously I was at CIBC. So I've been, and then prior to that, I was in-house or at a law firm. So been in in-house counsel for, I guess, about 17 years now. So at CIBC, we obviously were a retail bank, so I had to deal with a lot of French language issues from a retail consumer perspective, but also from a corporate commercial perspective. And today at CACIB, Crédit Agricole, it's strictly a commercial corporate bank. So don't have to deal with the retail folk, but happy to answer any questions regarding that aspect. But I do deal a lot with HR issues and obviously IP issues that both Tanya and Francois are going to speak about today.
Thank you, André. And on that note, Tanya, if I can ask you, could you start with a look before we go into some of the meaty items around certainly employment, which I know has been a big topic for many of our attendees today, to talk a bit about the background of the actual the legislation, how it came about, and where we are in its evolution today.
Sure, thanks, Gary. So Quebec's had French language laws for a long time, initially with Bill 101. And with most of those French language requirements being primarily set out in what we call the Charter of the French Language. However, the current government decided to do an overhaul of the legislation through what's commonly referred to as Bill 96, which came into effect on June 1st, 2022, and we've had a few webinars about already. Certain of the amendments came into effect immediately, while others came into force 3 months, 1 year, 2 years, or 3 years later. So we're approaching the 3-year mark for those obligations that come into effect this year. The legislation aimed to further promote the French language and reiterate the formal recognition of French as the official language of Quebec. And Bill 96 created over 200 amendments to the Charter and to other pieces of legislation. Evidently, after the amendments came into effect, as is normal, there were naturally many questions around the meaning of certain changes, and many provisions required clarification. So on January 10th of last year now, the government of Quebec published the draft regulation to amend mainly the regulation respecting the language of commerce and business, which was a regulation that already existed under the Charter, but needed some modifications to come and clarify the changes that were made to the Charter through Bill 96. That piece of legislation went through some consultation, and after that was further amended, and its final version has now come into effect. So there is now a modified regulation respecting the language of commerce and business, which is in force since June 26th of last year. The changes in that regulation primarily focus on things like inscriptions on products and documents related to those products, public signs and posters, commercial advertising, and most significantly, what we commonly refer to as the exception trademark. It also clarified certain questions around contracts of adhesion.
Thank you, Tanya. And it is obviously this was built upon existing legislation, so it wasn't a lot of net new. I think the one interesting thing as Bill 96 came into effect, it made people realize, and a lot of stakeholders realize, there were a lot of other obligations they may have not already been complying with, because not all of this was net new as it was realized. And Tanya, certainly there's been a lot of effects around employment, HR items, etc. Could I ask you to highlight some of the key considerations and what in-house counsel or HR departments that may be in attendance today consider as they go into as they plan for their respective departments?
Sure. So the good news is that not much has changed since we last sort of presented on this topic or spoke about employer obligations under the Charter since the implementation of Bill 96. There are quite a few employer obligations that are currently in force. Most of them came into force progressively and have been in force since June 1st of 2023 at the latest. There is one coming into effect. The only one left in the employer space to come into effect is touches on franchisation, which I will speak about a little bit later. But I'll just do kind of a brief overview of what those requirements are, starting with the most important, which is employment agreements. Employment agreements now, since Bill 96, have to be provided to Quebec-based employees in French first, and that is in every instance. There's no exception to this rule except if the agreement has been negotiated between the parties. And we really only see true negotiation between the parties at the executive level. Most of the time, an employment agreement is a standard form agreement and does not have much room for negotiation between the candidate who's signing on the dotted line and the employer. And so that means that they have to be provided in French first. And then if the employee requests it, it can be provided in another language. The struggle that we've seen, the question that we're always asked is, can we provide them at the same time? Can we not just give them both? How do we go about doing this? And, there hasn't been any clarification in the legislation, the newest legislation. Really what's supposed to happen is that it's French first, and then if requested, it can be provided in another language. That being said, given what's been sort of determined in terms of contracts of adhesion, we think the risk is minimal to provide them at the same time, but it's still not 100% compliant with the legislation. So that's one of the struggles that we've been, the questions that we continue to be asked. And I'd say that this is one of the ones that employers are complying with the most. Another struggle is that communications to employees, written communications to employees, have to be in French unless the employee has requested to have them in English. Now, this is more easy to deal with than the employment agreement requirement. And that's because for the most part, it's easy for the employer to say, what's your preference? And if your preference is in English, then we have it in your employer file or your employee file. And then from there on in, we know that we can communicate with you in English only. Or if you prefer, then we have to communicate with you in French. The struggle in this department is not necessarily with the very formal written communications. It's more around the informal communications, you know, manager to employee. What does that look like? If they've communicated with me in English in the first instance, do I have to reply in French? So we're getting a lot of questions like that from employers. And generally speaking, it's a very organic sort of discussion. If somebody is writing to you in English from Quebec, you can respond to them in English. You can imply that they're okay with you communicating with them in English. But it's always better to have that formal choice in their employee file, and that's what we've been recommending to our clients. Other aspects of HR that are important to remember are, you know, the requirement for somebody to speak a language other than French in order to be able to have access to a job. That is something that our clients are doing less and that we're struggling with convincing them to do, I think, because you have to do an assessment in order to determine whether there is truly a requirement for that job or the person in that job to have knowledge of a language other than French. So that means that you do have to assess whether truly the job tasks require the person to speak, let's say, for example, English. You have to assess, is there anyone else in the business who could undertake the English parts of that job who's already here so that we don't have to require it of the new position. And the employer has to try to limit as much as possible the requirement for somebody to speak a language other than French in order to have access to a position. So the formality of that is something that employers are not quite meeting yet and that we have to keep reminding them of. And then, of course, if you are requiring that of a candidate, you have to indicate it in your job posting. You have to say why it's necessary that they have the language skills of having language skills other than French in order to have access to that job. Offers of employment, of course, have to be in French or in French in another language. And this is something that employers don't struggle too much with now because simply of the platforms that are available to post jobs. Typically, in the Canadian space, you will have the opportunity to post your jobs in English and French, and you'll be at the same time reaching the same target audience. So that requirement that job postings be made in English and in French or in French and another language to a similar or comparable target audience is generally being met by employers without too much difficulty.
Tanya,
Go ahead.
To just jump in quickly, just before you continue with the further thoughts, just for the purpose of the audience, because I think at this point we have the bulk of the attendees. If you have any questions for our panelists today, feel free to throw them in the chat. I'll try to intertwine them as we continue on, as opposed to leave them for the end. And naturally, if we can't get to them, we'll try to do anything after the fact as well. But for the purpose of today, I'll try to intertwine them. Sorry, Tanya, I'll pass it back on to you. I just thought, let me throw that housekeeping item now that we have the majority of the attendees in place.
Sure. One new requirement that I don't know that we've actually discussed in the past is that there's a new corporate filing requirement that pertains to the workforce. So companies that are registered in Quebec's corporate registry who report having between 5 and 49 employees now have an obligation to disclose the proportion of employees in their organization who are not capable of communicating in French. And they do that on their corporate annual filings. So it's, there's specific forms, and then on that form, you indicate the proportion of your workforce that cannot work in French. And companies have asked us, how do we determine that? Do we poll people? Do we do a survey? And so we've helped them through that, actually through, polling to determine whether we ask the individuals to self-report whether they feel like they can work in French, so that the company can then report it to the corporate registry. And capable of communicating in French is generally defined as the ability to complete tasks at work in French. So not very clear, but the corporate registry considers that this includes the capacity to understand instructions in French, to attend meetings and understand them in French, to receive training in French, to draft documents in French, and to serve customers in French. So to the extent that your employees can do that, then they are capable of performing their work in French. But if they cannot, then you will have to include them in the proportion of individuals who cannot carry on their duties in French, and then report that to the corporate registry. I think that covers most of the changes in terms of outside of franchisation. So I'll now speak a little bit about franchisation and what that is, and the changes that have come about, unless you wanted to stop me there, Gary, for any questions.
No, that's perfect. I think franchisation is an important piece, Tanya. The only other thing I would like you to cover as part of that as well is, as a question that had come up in advance of this session, is how do we manage software to the extent software can be that is not available in French already and to be made available to employees? What can be done in that context?
Sure. Software is one of the things that was not modified by Bill 96. So it's something that was under the previous charter, and that continues to be the rule. If the software is available in French, then you have to make it available to your employees in French. It's part of the general right that the employee has to conduct their work in French. And so if we're talking about, for example, the Microsoft Suite, which is available in French, then the employer has to provide the option to the employee to use the French version. If a software does not exist in French, there's a lot of companies that have their own internal software that they've created for their own purposes. There's not an obligation to translate that into French for the employees to be able to use it in French. If they're using a software that's created by a third company that's not available in French, there's not a requirement to seek out an equivalent French version. It's really when the French version is available that it has to be made available to your employees in French. Now, in terms of franchisation, that may address some of typically the software question is dealt with in the context of franchisation, because the OQLF will look to see whether you're actually providing the French version, and that's where you'll have to make sure that you're doing that so that you meet the franchisation obligation. So what is franchisation generally? It's basically a set of rules in the Charter of the French language that aim to ensure the use of French is generalized at all levels of the company in Quebec. Currently, what the charter says is that a company with 50 employees or more in Quebec has a period of, for a period of 6 months, then has a period of 6 months to register with the OQLF. So as soon as you have an average of 50 employees for a period of 6 months, you have 6 months to register with the OQLF, the Office de la Langue Française, which is the government body that enforces the Charter of the French language. However, this franchisation requirement, the threshold of 50 employees, will be coming down to 25 employees on June 1st of this year. And this is the last obligation that comes under the employer sphere that comes into force this year. Once that threshold of 25 is met, as of June 1st of this year, companies have to register with the OQLF and then document the use of French within their organization in what's called a linguistics analysis process. So the OQLF has a form. Employers have to complete the form and essentially analyze and set out where and how they use French within their organization. And they have 3 months to do that. If the OQLF looks at your linguistics analysis and is satisfied there's sufficient French in the organization, they'll register, they'll give you a francization certificate. But in almost every situation that I have seen, they are not fully satisfied. They come and inspect the workplace, they review the analysis with the company, and then they prepare a francization plan with the company. And then the company has to comply with that francization plan collaboratively with the OQLF in order to get their francization certificate. The francization program has to generally be met within 3 months of having been determined with the OQLF in order to be able to get the francization certificate, though in my experience, they're open to extending that deadline if they see progress. And I think, there are some requirements about francization committees and things, but I think that's getting too much into the nitty-gritty of things. But generally speaking, the thing you have to retain as an employer is that threshold is coming down in a few months. And so there's going to be a significant amount of companies that are currently not captured by this requirement that will be in about 6 months' time. So keep it on your radar.
And Tanya, I can see the questions flowing in as you talk about it, as I expected. And some of these you've addressed that in terms of declaration is done through the forms available through OQLF, and also for some of the attendees that haven't dealt with OQLF before, the ability that it's not just sort of a hollow body, like there's a communication and you can come up with a plan collaboratively, etc. That it's not just sort of a system of sticks, but that it can be a sort of a two-way system of communication, as long as you don't ignore the just like any regulator, you can't just ignore them. You actually have to engage in conversation. So that's very helpful. Tanya, I will come back to you with some of the questions that as they are accumulating here, but I want to give André an opportunity, because he's been in-house and has had to deal with these from an in-house perspective at 2 different banks. From that perspective, André, any recommendations for sort of in-house counsel or some of the leaders that we have on the call in-house in terms of how to tackle some of these, order priority, how to triage, perhaps what to tackle first, etc.?
Certainly. Would say that definitely the HR front is definitely, I think that's why we led with Tanya first. I think the HR related French language issues is definitely has to be prioritized, simply because you are dealing with your employees and you want to ensure that your employees are happy, and obviously you want to ensure that you're meeting all legal requirements. So I took a couple of notes listening to Tanya. So, on the employment agreement side, and again, I agree with Tanya, we don't know, we'll see what jurisprudence decides coming in the future, but we've gone with a bilingual approach where the employment agreement is in French first and then in English second. And hopefully that will meet the requirements if it ever goes to court, which I'm sure it will one day. And then with respect to communications, it's definitely a tricky question. And I think there's still some debate out there. I don't know if Tanya wants to interject or not, but whether or not you can actually go to the employees and ask them for their preferred language, or they basically have to come to you and tell you what their preferred language is. There's a couple of ways around dealing with that without actually having to answer that question. One way is in your employment agreement, you can have like an annex or a schedule to it where they actually provide their personal information, and then they can state what their preferred language is right there. And you should or I would recommend you ensure that there's a good little sentence there stating, by writing down that it's English, you accept to receive, all future written communications from your employer in English. But obviously you can revoke this or change your language of choice at any time. So that's one way of doing that, is when you're hiring the person and onboarding the person, you ensure you tackle that issue there. It's obviously much more complicated when you already have maybe 4,000 employees or even 50 employees, and now you have to deal with this new reality. But there's ways of resolving that. Another way of resolving communications without even having to get into the rabbit hole of asking employees what their preferred language is offering AI or automatic translation services. I know Microsoft 365, for example, offers that service where if you're using Outlook and you get an email that comes in English, you can set it up so it automatically translates into French or vice versa. So that's another tool which you're probably more than familiar with, Gary, with AI translation. The one risk with that, though, I would say, is that depending on the AI translation that you're using, it might not be best for certain situations. It obviously gives a great overall translation for general matters, but if you're getting into the legalese, then you probably want to make sure that you have a more robust translation provider. Completely agreed with Tanya on the job descriptions. It's become it's just a couple more conditions that you have to deal with now. You're doing your assessment. You got to make sure that you respect the limitations. So you've got to think about things a little more, foresee things a little more in advance. I think one of the questions and Tanya had mentioned this about the REQ, the Registre d'entreprise de Québec, that's the corporate filing that you have to ensure that Tanya was referring to, that you need to now mention whether or not what percentage of your workforce is capable of functioning in French. So any in-house counsel on the call, if you're not doing your own corporate filing, but you probably have external counsel, then that's what you need to speak to them about, is the REQ. The other thing about the REQ that some people are not aware of is that the OQLF and other Quebec administrative bodies use, like the CNESST, which Tanya is more than familiar with. They will use that REQ, the information in the REQ, to confirm the information and so forth. So, the OQLF uses it to see if you've gone over 50 employees, for example, and they see that it's been there for, let's say, over a year or what have you, they're going to start wondering how come you haven't filed with them your first registration or your first filing to begin the process. So that's something that you have to make sure that information is correct. If it's not, then you shouldn't wait for your annual update. You should go in there and change it. And then over on the francization, I think it's a good tool. People need to see it as a helpful tool and not something that adds another layer of bureaucracy or administration. And the reason why I say you should look at it from a positive perspective is it's a group of people. Half the people are representing the employees, the other half can represent management. It can obviously be more than half representing the employees, but that's the minimal thresholds. But it ensures that there's communication going between management and employees. And sometimes you discuss matters that aren't necessarily a language issue, but are some other issues, and that can help kind of circumvent having other type of employment or HR issues down the road. So I see it as a positive factor. And from the OQLF perspective, I would say that people sometimes get a little tense and a little stressed out about having to deal with them, but they're actually, on the most part, they're actually very friendly people, and they're there to try and help you. They're not there to hit you with a stick. They're more there to try and give you some carrots and try and help you find ways of finding solutions to the regulatory requirements. So I'll stop there and let Tanya interject if she has anything she wants to say about that.
Yeah, I think I would just agree with you in terms of the fact that the OQLF seeks compliance. They don't seek to penalize. Their aim is not, okay, you've breached the requirement, we're going to impose a penalty right away. They really try to get you to comply. They are amenable and they understand that it requires a heavy lift for certain things. I mean, one of the things that I do help liaise with the OQLF for my clients, and a lot of the complaints that we're seeing coming in are with respect to customer service, because customer service needs to be provided in French, and now to a larger population. It applies business to business now, where it didn't before, and with respect to website translation, because companies are selling into Quebec, they're offering products to the Quebec population, but their websites are only in English or English and Spanish or whatever the case may be. And they don't even realize that they have to have their websites in French, but the OQLF gets a complaint, sends a letter saying you have to do this. As long as you say, okay, I'll do it, I need this much time, they will work with you to make sure that they get the compliance versus, being harsh in terms of imposing penalties.
Thank you, Tanya. And I'm switching gears to Francois. Francois, it's trademark protection is key, and certainly there's been some deadlines and considerations on that front. But as you can imagine, with some of the attendees here today, some of the questions that come up in advance have been around labels and signage, and what are some of the general rules to be aware of in light of the new legislation. So I'll pass the virtual mic on to you, certainly for some of the general items, and then address some of the questions that keep coming up through the...
Absolutely, thank you. So, correct, maybe two of the motivations behind Bill 96 for the language of commerce and business, sorry. One of them is for signage, and the other is for products, packaging and labeling. So maybe signage first. So as you may know, the rule for storefront signage has been, well, not only storefront signage, but signage in general in commercial advertising, French must be markedly predominant. This has been the rule for a long, long time. Now was it in 2016, the regulations were amended. So if you have storefront signage and you have a non-French trademark, then you need to add French, a sufficient presence of French on the storefront signage. Why is that? It's because the rule of markedly predominance of French excluded the non-French trademarks. So if you have a facade, a storefront, you have a non-French trademark, you don't take it into account when assessing if you have a markedly predominance of French. Now, because of that, they said, well, if you have a non-French trademark, you need to add some French, but there were no size requirements whatsoever. What Bill 96 did was to address one of the concerns of the government, saying we need a stronger French visual landscape. So that's why it says that if you have a non-French trademark, French must be markedly predominant on storefront signage. Well, that was a big, big surprise, because just imagine any kind of store, and I'll always use this example. For example, Canadian Tire is a famous store in Canada, of course, and you have a large Canadian Tire, and if French needs to be markedly predominant on their storefront signage, does that mean that you need to add French twice as large as the trademark? So that was a big concern. And when we saw the first draft of the regulations that were published, like Tanya said, on January 10 of last year, it said that to comply with that, French text has to be twice as large. And good thing, the final version of the regulations that were published on June 26th, that will come into force on June 1st, 2025 for the trademark portions, says that the space allotted to French has to be twice as large. So that means that you can have a big trademark, and as long as you have other French here and there, smaller characters, that's fine, as long as the whole space occupied by French is at least twice the size. So that was something that was brought by Bill 96. Bill 96 also said that to benefit from the trademark exception that allows businesses to use a non-French trademark exclusively, so without a translation, that trademark needed to be registered. That was huge, because getting a trademark registration is not that easy. It takes a long time in Canada. It used to be up to 4 to 5 years to get the trademark application examined. Now it's faster, but it takes a few years to get a registration. But fortunately, in the final version of the regulations published on June 26th, they'll come back to the recognized trademark exception. What is a recognized trademark? Just a trademark recognized under the Trademarks Act, so registered, obviously. Trademark that has been used without a registration. There's a debate among some of us to what extent a trademark needs to be used to fall into the recognized trademark exception. I think minimal use should be sufficient, but we'll wait to see what the court says about that. The other big change for the big concern addressed by Bill 96 for the government was packaging and labeling. There was this ongoing strategy by businesses that say, wait a minute, under the language laws, if I have a registered trademark, I can use it exclusively in that other language. So businesses were registering a whole label as a trademark. So we have the trademark and lots of descriptive information on that label and saying, you can't touch me. It's a registered trademark, so you can't force me to translate it. Now, the government has been on, this has been on the government's radar for a while. And personally, I don't think you should be using the Trademarks Act to register something that is not meant to distinguish your goods and services, but that's beside the point here. So the government says, no, we're not going to go through with this. So they amended the language laws to say, if you have a non-French trademark, that's fine. But anything descriptive or generic, well, generic or descriptive of the product within that trademark needs to appear in French on the product or a support attached to the product. That was a big surprise as well, because some trademarks do contain descriptive information. It's part of the whole branding thing. So at first, when we saw this, we were really, really concerned, saying, oh my God, so many trademarks are going to have to be translated on packaging and labeling. With the final version of the regulation, they provided a definition of what is descriptive, what is generic, and they said it includes the name of the product as sold. Now, what is the name of the product as sold? I think that's the Quebec government's definition of a trademark. I think it's a bit simplistic, but anyways, that's the definition they sort of provided. And it raises many questions. Can you have more than one name of a product as sold? In any event, if the trademark is descriptive or has descriptive terms or generic, but is the name of the product as sold, you don't need to translate it. You can use it exclusively in the other language. But if it's not the name of the product as sold, then it needs to be translated. I think again, the view of the government was to tackle this issue of labels registered as trademarks to prevent businesses, to allow businesses to avoid having to translate the generic and descriptive information. And that's how they drafted it. But it goes beyond the general intent of the government, I think. So lots of uncertainties regarding those. So I guess if you want to have some strategy, first is to assess how many trademarks are being used in Quebec that are not in French. Try to pull a portfolio of all trademarks. Verify if any of them are not registered. Any important trademarks, irrespective of language laws, should be translated, in my view. But if they're not registered, I think you should really, really consider translating them. It could be a budget issue, obviously, and some trademarks cannot be registered for any number of reasons, but as many as you can, I think that's one way to settle the issue. And I'm saying this because the OQLF, if they see a registered trademark, I think it's going to be easier for them to identify that trademark, say, okay, that's the trademark, that's probably the name of the product is sold, we won't touch it. If it's not registered, I don't know how the OQLF will react. We've heard through unofficial discussions with the OQLF a few weeks ago that they would consider as recognized registered trademarks or trademarks that have been recognized by a court decision. If that's the case, this is a big issue because common law trademarks should benefit from the exception without having to go to court. Anyways, time will tell if that's the interpretation that they will adopt. So for that reason, registering a trademark, I think, is an excellent strategy. And maybe one last strategy that I'd recommend, make sure it's the name of the product is sold. Because if you file a trademark application and add lots of words, and then you look at the product and you have part of the trademark that you filed for is here, and then you have a design and then the other wording over there, then I don't think you can say that's the name of the product is sold. So make sure that it looks like the name of the product is sold on the packaging so it's easier for everyone to identify it.
Thank you, Francois. A lot of information to take there. Luckily, this session is being recorded for anyone that wants to listen afterwards as well, in case you want to capture some of these. And André, thank you very much for addressing some of the questions in the Q&A in the process. I saw you were answering one live, and one just for the purpose of the audience, in case you didn't see it, was whether and if the software was really, and I'll pose this to Tanya, and I know André put in the relevant section of the legislation there, but if there's an additional cost for the French version, is it still applicable? And the context was very much that sometimes you have software available, but there may be additional cost for the French, and if that makes a difference. So, and that's, feel free to jump in, Tanya, but put in the legislation as well. So.
I'm sorry. So if I understand the question correctly, it's whether the fact that there's an extra cost associated with getting the French software, if it's available, if that's a consideration. No, unfortunately, the OQLF recognizes that there are costs associated and therefore is willing to give you time to comply, but you still have to comply. And so the cost associated does not come into factor here.
And I think the cost piece we've seen as a thematic throughout it. Obviously, anytime you're doing business in different jurisdictions in other countries as well, where you're dealing with other languages, that there's an expectation to do this, and that it's no different. This seems to be the thematic to the extent we can look at it. And André, I want to come to you for some of the in-house considerations around IP or otherwise, and a little bit about the contracts of adhesion. But just before we do that, one of the questions that came up, and this either to Francois or Tanya, there was an expectation that there would be more enforcement from OQLF to date, and we haven't seen necessarily anything out of the ordinary. Do you think there's been a delay, and that more is to come, or is it unknown? And because the speculation was, hey, until the regulations come out and there's a bit more clarity, and then sort of you want to allow a certain amount of time after the regulations come out to make sure that people comply. Do you foresee any changes in that context?
I'd say from my perspective, there has been enforcement. They take different approaches based on the type of complaint that they're receiving. In my experience, when they receive a complaint about a website translation, they will send a claim letter saying you have until this date to get back to us, and you have to get back to us, or we will take other action. But for things like customer service, they'll send a letter saying, we received a complaint that you're not providing customer service in French. We expect that you will comply. And then that's it. There's nothing more unless they receive another complaint about customer service for the same company, in which case then they'll send a claim letter. They'll escalate the enforcement. So I have seen enforcement with respect to customer service requirements, and sending out those letters and escalating when they receive multiples. I have seen enforcement with respect to websites. I have not seen very much enforcement with respect to employment. And I don't know if that's simply because employers are really taking the necessary steps to make the changes that need to happen, or if it's simply because they are getting less complaints. Typically, when we do see an employment complaint, it's usually an anonymous complaint filed by a disgruntled employee who's either just been fired and is not happy, or who is really feeling that their French language rights are not being met by their employer because they're doing nothing to try to comply. But those are very few and far between.
Thank you, Tanya. Important perspective. Francois, I'll pass it on to Andreas, unless you have anything else to add on that front.
Well, yeah, for trademarks, so it's not yet enforced. But one of my colleagues actually is dealing with the OQLF for a complaint regarding the rules that are not enforced yet. So it was very, very surprising, saying, well, those rules aren't enforced yet. And the agent was pushing, saying, no, but you need to do this. So is there going to be an avalanche of complaints starting June 1st? Perhaps the OQLF will be overwhelmed, so we won't get so many complaints. So for example, if you want to register a trademark and it's not registered by June 1st, 2025, I don't think it's going to be the end of the world on June 2nd. I think we do have time, and like André and Tanya mentioned, the OQLF just wants businesses to comply. So worst case, you get a complaint, you can buy some time to make sure you can comply after that.
Thank you, Francois. And André, if two pieces for you. Certainly anything, again, from an in-house perspective on both those fronts, but also a little bit about contracts of adhesion and knowing that that's, while there wasn't anything new, I believe, in the regulations to clarify further there, but the contracts of adhesion was an item that overall for Bill 96 was had a certain amount of impact. So I'll pass it on to you for any insights on that front.
Yeah, so just touching on the customer service OQLF, the one thing that is something everyone needs to recall is that when you get a complaint from the OQLF and it's coming from either an employee or from an HR side or from a service customer service side, the information is anonymous, so you will not know which employee or which client has actually made the complaint to the OQLF, which sometimes renders things challenging because the OQLF, asks you for your perspective on the complaint, and sometimes without knowing the actual fact pattern of the situation, it renders it difficult to provide a response. So in those cases, you try and create the best response that you can. Sometimes we try and backpedal and do some sleuthing to figure out, based on the information, if you have a database, you're able to kind of do a search on that particular scenario, and then you might be able to find out who the employees are, who the client is. Obviously, it's not important from that angle, although I think it is important because obviously it'd be nice to be able to reach out to the client or the employee and let them know. But at the same time, you have to be careful because it could be kind of the equivalent of whistleblowing, and so you obviously don't want to. You have to tread water carefully, I guess is what I'm trying to say. On the OQLF side, I agree with Francois's comment. They are definitely overwhelmed. I think everyone might have noticed in the media, the Quebec government has increased the budget. I think it's $100 million, if I remember correctly, over the next few years to try and help the additional regulatory requirements that the OQLF needs to now try and enforce. And so I think that's one reason why we're not seeing perhaps as much enforcement as some people might think. But again, as I think Tanya, François, and I have all said, they're really there to try and help us achieve the goals of the government and not try and penalize us. It takes a lot to get your name on the OQLF, I'll call it the bad boy list, which you definitely don't want to find yourself on that list, because then the media looks at that list and then they'll draft up an article, which might not be flattering for your enterprise. So I think you do have a lot of checks and balances to ensure that your name doesn't get on that list. So seize those opportunities, because I think everyone on this call realizes that our roles are really to limit both reputational risk and legal risk. And reputational risk sometimes is much more scathing than the legal risk itself. And then a couple comments on what Francois mentioned, or a couple thoughts. I've been busy with coming up with incorporating some new legal entities, and so the one thing I try and do is try and come up with a bilingual name that helps a lot with respect to meeting the trademark requirements and the language requirements, is by coming up with bilingual names, whether it's for the actual corporate name or if it's for a product, name of a product or what have you. Or another way, and François can advise on this more, is coming up with a name that's not particularly in English or in French, but it's kind of a mixed word, or it's a word that's conceived from various language, and it gets the point across of what you're trying to market, but it's not considered to be English or French, or potentially any other language, to be honest with you. And then definitely on I think the key thing everyone has to remember from an IP perspective, or from a signage perspective, actually, is that the Charter of French Language is really to ensure that the signage is predominantly in French. And so the key thing is finding how to ensure that you're meeting those requirements. And so I think François mentioned it, is two of the key ways of doing is when you have the font size. If you're talking about posters, for example, You have the font size 2 times larger in the French version than the English version, or you have 2 times the number of French posters than English posters. So that's one way of tackling that. And one other point I mentioned was sometimes people ask about the French. Is there any requirement that the French be Quebec French, or can we use French from France, or can we use French from Belgium, or pick any other Francophone speaking country? And actually the law doesn't say anything about that. So I think the game plan is to try and just ensure that you have your products and documents available in French. But obviously from a reputational and legal risk, depending on what the product is or what the contract is, you want to make sure that maybe it's more Quebec French in certain situations, because obviously otherwise you can end up finding yourselves in a situation because you might have used words that are more common in another jurisdiction than in Quebec. But for general types of situations, it's fine to use any type of French. And then on contracts of adhesion, I'm going to assume everyone knows what a contract of adhesion is, but quickly, it's basically a contract that one party basically has drafted. So it's a unilateral contract, and the other party basically has to sign it. It's slightly different to what some people call standard clauses, where you might have certain clauses that are unilateral and then are thrown into a contract that's actually negotiated by both parties. So slight little subtlety there. The June 26 amendment gave a couple additional conditions that you need to take into account to meet Bill 96. And so it basically, it defined what is considered to be a related document to a contract, because if you notice in section Article 55, which is the section on contracts of adhesion in the Charter of French Language, basically alludes that a contract has to be available in French unless both parties have agreed to, or unless after having seen the contract of adhesion, both parties agree to sign it in another language. And it also includes any other related documents. And so what the June Amendment defined as other related documents to a contract of adhesion includes a document attesting the existence of the actual contract. So an example that they give is a certificate of insurance, for example. So you might get the policy, but then you actually get a little certificate, like a travel insurance certificate, for example. The second example was where it's legally required to have an annex to the contract, for example. So an example that they give is a termination form. So under the Consumer Protection Act, there are certain types of contracts that require to have a termination form annexed to the contract of adhesion. And then they have a catch-all, which is basically anything that's considered to be accessory. So that gives us a little more background on what can be considered to be a related document to a contract of adhesion. And they also talked about technological, how you can ensure that you're using technology and meeting the requirements. So they talk about phone, because there are certain people that come into enter into a contract via the phone. And so the question I think that was asked to the government was, how do you ensure that you've provided a French version of a contract if you're dealing with someone over the phone? Because it's not like you can show them the contract over the phone unless you're using maybe Teams or something, which is so the way the government responded with the amendment was that you need to ensure that the French version was the French version of the standard clauses have been consulted through some technological means, which could be the use of Teams, for example. Or another example is you inform the client, please go onto our website. You send them a text with maybe the link to the website. You wait to hear, and you record the call, and they say, yes, I've clicked on the link. I see the French version, but no, I want the English version. And then The other situation where you do not need to have necessarily provided a French version of the contract is that the contract needs to take immediate effect, and there is no technological way of showing the standard clauses or the French version of the contract to the client. So again, in that type of situation, I would want to make sure that the call is being recorded and that you can demonstrate that the client has confirmed that they have no means of speaking to you through Teams or through some type of, or clicking on a link to actually go see the actual French version of the contract. And therefore, I think you would protect yourself fairly well in that type of situation. I think that's what I was going to say for contracts of adhesion. Oh, and they didn't really get into websites, but it's clear that on a website, technically, if you have a contract of adhesion on the website, even though the client has, let's say, logged in onto the English side of the website, you still have to be able to demonstrate that when that client is choosing the English contract of adhesion on their website, that you have made available the French version to them. So unfortunately, it means redoing your websites or finding a way of ensuring that before the client actually signs off or clicks OK to having accepted the English version of the contract of adhesion, that a French version has been presented to them and that they've actually opened it, read it. I put that in quotes because most people aren't going to read a 10-page contract in a minute or 30 seconds, but at least you can demonstrate that they've potentially scrolled through all 10 pages, for example, to click on the OK or accept button at the end. So that's it, because I know we're running out of time.
No, thank you, André. And Tanya, and perhaps to you and Francois, I know André touched on this. In the world where the AI is these days and a lot of translation can be done with AI, what are some acceptable uses where some of the audience can say, hey, for some of these use considerations, we can rely on an automated level of translation, perhaps not just something out of the box with some level of customization, but are there some use cases to consider that?
Yes, in the employment space, there's a lot of communications that might go out from head office to employees that are of consequence, but that do not have any legal impact if they are misunderstood or a word is not necessarily the way it should be. So where you're saying, hey, we're going to be having the office is going to be throwing a summer party, and you want to have a French version, you're sending it to all your employees. That's something that you can make use of AI to translate. The thing I caution against is really legal documentation. There should be a higher level of review in legal documentation. And like André mentioned, yes, French from France and French from English, French from Canada is okay in most situations, but in the employment space, the word licenciement means a very specific thing in France and a very different specific thing in Quebec. So be careful when you're translating legal documentation. That's my caution. But otherwise, when you're trying to do a translation that needs to go out quickly to your employees at large, it can be a very useful tool.
And jump in. Yeah, so for commercial publications, yeah, obviously that can be very useful, even for inscription on products or whatever documents that accompany the products. But just a word of caution, the French version for either products or whatever is inside the products, and for commercial publications like website, has to be available in French on as favorable terms as the other language. So if you have a website in English, for example, and the consumer needs to click to have a translation generated after that, I don't think the French version is available on as favorable terms. So if it's automatic and consumers doesn't see a thing, then that's perfect. But if he or she needs to do something to get the translation, then this might be an issue.
I was just going to jump in, Gary, on the comment of Francois. It's another key thing to remember is actually if you're providing, for example, a customer service toll-free number, for example, a call center in Quebec, you need to ensure that the hours of operation on the Francophone side and the Anglophone side mirror each other. You can't have extended hours for the Anglophones and not for the Francophones. That's just something else that everyone needs to take into mind.
No, thank you all. I know we're at time and appreciate the audience's questions and for joining us today. Tanya, Francois, and André, thank you very much for the time. Avi, thank you for partnering us on this. I know I'm sure maybe many of the members of Counsel would have found this helpful. I thank you all for the time and appreciate looking forward to more webinars together.
Thank you, Gary,
Thank you
for the
all.
invitation.
Appreciate
Bye.
it. Merci.